Today's discussion will reflect upon the rights implications of this legal process as well as the impact it will have on the youth and rehabilitation. This event is being hosted by Enfold Health Trust as a part of the satellite session of the 5th World Congress on Justice for Children 2025. This World Congress is a part of the Global Initiative for Justice for Children. This initiative is being led by several international organizations who come together to hold the World Congress. This is the 5th World Congress and the past 4 World Congresses have been held in 2009, 2015, 2018 and 2021. The topic for this year's World Congress is Advancing Child-Centered Justice, Preventing and Responding to Violence Affecting Children in the Child Justice System. It will emphasize the critical need for justice systems to place children at the center while addressing and preventing violence and systemic challenges that jeopardize their safety and development worldwide. Today, as we speak, the main event is happening in Spain, Madrid, with several satellite sessions taking place regionally, which are hosted by organizations, state agencies, academic organizations, and Enfold is honored to contribute to this larger dialogue on children in the justice system. So, before we begin, a few housekeeping points. This session will run for approximately 90 minutes. We will first set the context, so we ask you to bear with us while we give a brief overview of the legal system and the procedures for children in conflict with the law. After that, we will head on to the panel discussion. The last 20 minutes will be open house, so we invite you to ask questions and share your comments then. After the open house, we invite you to join us for simply coffee and snacks. So, before we get started, just a very brief introduction to the justice system and preliminary assessment process, which will be the topic of our discussion during the panel. So, as you know, this year marks the 10th year anniversary of the introduction of the Juvenile Justice Care and Protection of Children Act 2015. This repealed the previous law, which is the JJ Act 2000. It brought in several changes with respect to the law and procedure that concerns children in conflict with the law, as well as children in need of care and protection. The biggest change, however, was the introduction of the transfer system. This significantly changes the legal landscape as it affects children in conflict with the law who are above 16 years and alleged to have committed heinous offences. This change in the law was largely triggered by the Delhi case in 2012, and after several protests that followed, because one of the accused persons in that case was a child, the law was changed, and we see a significant shift from a rehabilitative system to a punitive one. So, as you know, the JJ Act defines a child as any person of any gender under the age of 18 years. A child in conflict with the law, which is a group of children that we will be discussing today, is a child who is alleged or found to have committed an offence who has not completed 18 years of age on the date of the commission of the offence. So, we have two sets of processes. There is a process for children who are less than 16 years and a process for children who are 16 to 18 years. Where the child is below 16 years, irrespective of the nature or the gravity of the offence, all of them will be dealt with by the Juvenile Justice Board, which is a statutory body under the JJ Act. They will undergo an inquiry and the JJB will dispose the case and provide orders, which we will come to shortly. For children who are 16 to 18 years, here we see two different sets of processes depending on the nature of the offence. For offences that are petty and serious in nature, they will follow the regular process of going for an inquiry before the JJB and orders that will follow. However, where the child is above 16 years and alleged to have committed a heinous offence, heinous offences are offences for which the minimum punishment which is prescribed under the criminal law is 7 years. So then we see that they have to first undergo a process called preliminary assessment, which will be undertaken by the JJB. Pursuant to that assessment, it will be determined whether they are to be treated as a child in the system or be treated as an adult. If they are treated as a child, they will undergo an inquiry by the JJB, or if they are going to be treated as an adult, they will be transferred to children's court. So today we are really dealing with this group of children that is 16 to 18 years who are alleged to have committed a heinous offence. We will talk a little bit more about the preliminary assessment. So this is a process that has to be mandatorily done by the JJB for all children who are above 16 and alleged to have committed an offence that is heinous in nature. The law requires them to look at 4 factors while determining how to finally treat the child. So the 4 factors outlined in the law are physical capacity to commit the offence, mental capacity to commit the offence, ability to understand the consequences of the offence, and the circumstances in which the child allegedly committed the offence. So doing such an assessment, they can take the help of experts such as psychosocial experts, psychological experts, experts coming from the field of psychiatry. This is also required to be completed within 3 months. Following this assessment, they can either decide to try the child as a child, which means they will go for an inquiry before the JJB. So here, a regular inquiry will be held as per Section 14 of the Act, and if the child is found to have committed the offence, there are a number of rehabilitative dispositions that the JJB can order. Some of these are fine, probation, community service, group counselling, or as a last resort, they can be placed in a special home for a maximum period of 3 years. Apart from these, there are also additional orders that the JJB can pass that requires a child to attend school, attend vocational training, attend a re-addiction program, etc. The important point here is that all records with respect to this procedure are to be destroyed, and a conviction here is not disqualification for any aspect of the child's life. Now we will move to the other disposition. So after the preliminary assessment, if the JJB determines that this child is to be tried as an adult, then the regular criminal justice procedure outlined in the main essence, which now replaces the CRPC, that process will follow before the children's court. The children's court is a regular sessions court which is designated as a children's court. So here the criminal justice regular process will take place, and if you are found guilty, then this child will be placed in a place of safety, which is a special institution, until the child reaches 21 years of age. At this institution, the child is to be provided with informative services, and there will be follow-up which is conducted. After the child attains 21 years of age, there will be yet another evaluation that takes place. Here, the children's court has to determine whether the child has undergone reformative changes and can be a contributing member of the society. If after this evaluation the court can agree to release the child on a conditional basis, or the court can determine that the child is not reformed and is not a contributing member of society, and can order the child to spend the rest of the sentence in a regular adult jail. There are no limitations on what the sentence can be, and the applicable provisions will take effect, with the only exception being that the death penalty cannot be provided, and you cannot pass life imprisonment without the possibility of release. The other aspect is that here there is no such loophole of disqualification. All records will be retained and all disqualifications as per law will follow. So this is a brief snapshot. After the preliminary assessment, if the child is transferred to the children's court can once again also determine to try the child as a JJB, in which case it can proceed to pass orders as a JJB. But at this point, if it proceeds to try the child as an adult, then the child is fully transferred to the adult system, and all regular criminal justice system procedures will follow. So with that brief snapshot, we will move on to the panel discussion. I request all the panel members to take their seat while I introduce them. Specialists with over 18 years of experience in child protection, education, health, and social development sectors. She has held diverse roles in both national and international organizations. She currently leads the Access to Justice project at the National Law School of India University. The project aims to provide legal and psychosocial services to children in conflict with the law and aims to strengthen the juvenile justice system by building the capacities of the stakeholders in the system through research and analysis. Our second panelist, Cathy, Roshini. She is a mental health professional and PhD scholar at NIMHANS, Bangalore. Cathy brings critical insights from her work in child mental health and well-being. She has over 3 years experience as a junior consultant in the Department of Child and Adolescent Psychiatry at NIMHANS. She works extensively with children experiencing mental illness, children in need of care and protection, as well as children in conflict with the law. Our third panelist, we have Dr. Kalpana, who wears many hats. She is a counselling psychologist, a professor of psychology, and also a former member of the Juvenile Justice Board at Bangalore Urban. Her work spans providing capacity building to JJB members and professionals, and co-authoring a child psychology book for education. As a former JJB member, her dissenting judgments have been a bold towards against the child and sentencing of children in the adult criminal justice system. Dr. Kalpana also spearheaded the Mansa Wellness Center, a pioneering mental health initiative at the Organised in Bangalore. Lastly, we have Swagata, Raha, the Director of Research and Co-Director, Restorative Practice Organizations in India. Her work has spanned drafting juvenile justice rules for Karnataka and Madhya Pradesh, contributing to the Supreme Court Committee on Juvenile Justice and leading significant studies on the POCSO Act's implementation. She has also provided technical support to the drafting of the guidelines for recording the evidence of vulnerable cases, which has now been adopted in several high courts across India. We look forward to the rich and thought-provoking discussion and thank you all for joining us here. We will start with Swagata. Now that we stand at the 10-year mark of the National Literature Act, could you tell us what has been the key trends in conducting preliminary assessment? What is the data telling us, and what is the ground-level evidence studies telling us?
Thank you and welcome to this panel discussion. I will try and deconstruct some of those many flowcharts that you have just said to. And I'll break it up into 3 points. Again, I want to frame it into 3 buckets in increasing order of importance in my mind. First, I think I would say that there's very little data that we have. There's a huge data gap. We don't really know how many children are being tried in adults, how many children are being sent into care system, and then what is the outcome? Are they being sent to prison or are they being released? So that's definitely one gap that I can immediately see. The second I would say is in terms of procedure. When the system came, I think many of you recall this because the horrific Delhi Cabinet case. That's the context that really shaped this law. And at the time the law was framed, there are many of us in the room, many of us in the room who were actually part of policy related interventions saying that the law should not change. And at that time, the understanding was that this is an exception that is being created. It's not going to apply to every child who commits an offense. This is really meant for the worst of the worst, whatever that may be. Unfortunately, based on our own work in multiple states, what we see is that this has now become the default. It's not the exception. So if you're a child who's above the age of 16, you're accused of an offense that is called heinous. To simplify it, you will commonly think it is murder, it is rape, but there are many offenses that really come under the definition of a heinous offense. What we see on the ground is that this has become a system for juvenile justice courts who have a very heavy caseload to get rid of their cases. So they see it as a way of reducing the pendency. If I have 100 cases and if I have 40 such cases, I will just straight away say that please go ahead and transfer them, let the children's court deal with them. So we're not looking at an individualized approach to the child. Second, when we're looking at it's such a critical right, and we're not familiar, I'm sure all of us watch a lot of film movies and legal dramas, and you know how important legal representation is for anybody who's a victim of a serious offense. But when it comes to these children, the records that we read, the interviews that we have done with lawyers, with juvenile justice court, it tells us that lawyers are largely absent during the preliminary assessment process. So you have a child who's going through this process with no lawyer representing them in most cases. And what does that mean? So you are being subjected to questions, you have no idea how that's going to be used against you. You are also given the report that is going to be relied on by the court to declare that you have the capacity to commit this offense. So they are meant to take the opinion of mental health experts. The mental health experts are meant to give an opinion, but you will never see that report. Your lawyer will never have access to that report. Now, these are very, very critical rights for you to have to be able to go through a process like this, at the end of which you can be in a jail. And the largest, I think, the most significant problem that we have seen in the course of their implementation is a very foundational one. If we believe in the principle of you're presumed innocent until you're guilty, and if you've seen the criminal dramas, the first thing that the police does when they arrest you is that you have a right to be silent. Anything that you say is going to be held against you. Well, that's only on Netflix. It's only on TV. It's not in your life. So you have children coming into the system and they are told, we are here to help you. Please tell us the truth so that we can help you. And here is a child who is incriminating themselves. And once they have done that, the board is saying, you have shared your exact detail how this happened. You have capacity. And they are going to send you to the address. Or say if you have lawyered up and your lawyer has said, please be quiet, don't say anything about the incident. And the child does not. Then they say, you're so smart. You're so smart that you're so clever that you're not saying anything about it. So damn if you go, damn if you don't. So foundationally, how do these rights even be ensured in a system that is geared against you from the get-go? Just the very nature of the crime makes the juvenile justice court, think that they cannot overlook how great that crime is. And in that process, we are losing out on basic fundamental principles, which is what presumption of innocence. We are already assuming you have done the crime. Now I'm trying to understand what were you thinking when it happened. Do you really understand that if you hurt somebody, they will get hurt or they will die? So I'm already starting from the point of view that you've done this offense. And just to close with an example, because we were trying to understand how legally do this. Where are the tests really to actually ascertain something like this? Can it even be ascertained? And we found unique ways in which DJPs have tried to do this, where they give a hypothetical situation. Imagine you're on the road, you're walking with your sister, there are 3 men approaching you, and you sense danger. There is a tray with various weapons kept for you. There's a stick, there's a knife, there's a gun. What are you going to do? What's the right answer? Because no matter what you pick, it shows criminality. The right answer is, I will run away. Imagine the child who's being set up for this question and who's being given this option, and the only thing they think is, I have to pick one of these 2. So you set them up for failure at the get-go. And then you're attributing criminality to a hypothetical situation like this to then set the child into the other system. So I'll stop there.
Thank you, Swagata. You touching on the rights implications and also, I think, taking us towards the parameter of assessing the mental capacity and trying to understand what the child is thinking when it's happening. So that takes me to Dr. Kalpana. As a former JJK member, so how do you view the parameters that are listed in section 15? So, how is it possible to really assess what is the physical capacity of the child at the time of offense? And more importantly, what is the mental capacity of the child when you complete the offense? Because as I understand, the law doesn't provide any further guidance on this aspect. Good evening to everyone. Right at the beginning, I'm so glad I'm here today, and what makes me especially happy is that one word in the book, it's a former. I'm a former member because I think for the last 7 years I've been moving my breath. I'm not able to say a lot of things. So I would start off by saying that this section in itself is deeply problematic on several counts. And not the least as a medical professional because it is completely problematic for me. But like Swagata pointed out, it is constitutionally wrong, it is ethically wrong, it is scientifically wrong, it is morally wrong, it is wrong on multiple levels. Like how are we trying to do this entire business of trying to assess mental capacity? What really is this capacity that we're talking about? Every person in this room has not the capacity to commit a crime. Okay? And so, on what basis are we picking out this child out of the population and saying, no, let's figure out, maybe 1 month back or 2 months back, did you really have this capacity? And then to actually ask a mental health professional, with due respect to all the mental health professionals here, what are they supposed to do? What really are you supposed to do? What exactly is the mental health professional supposed to do here? Okay, first of all, the law uses this word psychosocial experts. Now, who really are these psychosocial experts? I don't know. I really don't know. We have psychiatrists who are trained in medicine and psychiatry. The way of diagnosis in medicine and psychiatry is very different from what section 50 is asking them to do. Or we have psychiatrists who are workers, we have social workers, we have counselors, we have psychologists, all who are trained for a very different purpose. So the role of mental health professionals, the way I understand it, in the juvenile justice system or in any work that involves children, is to try, because a very crucial role. And I would like to believe that mental health professionals, our role should be, what should be our action? Is to try and understand why did this child come into conflict in learning the first place? What happened to this child? What were the adverse childhood experiences that this child was going through? What was the psychological circumstances? What was the social background that brought this child into conflict with the law? And those are very crucial inputs that various mental health professionals can give, not for the purpose of declaring some child what are labeling this child and then saying you go and be tried and sentenced with an award. No, not for that purpose, not for the purpose of saying what can we as adults do to help this child for treatment, for counseling, for as a family, education, employment, vocational training. There are a million things that should be the ask of mental health professionals, not to say this is capacity, mental capacity, what was this child thinking at that time. That really is not what mental health professionals are trained to do. Yeah, so there is no scientific basis, there is no neuroscience, there is nothing that seems logical in any way, whatever the section is asking of mental health professionals. The second, also I think very important factor to remember is what is the composition of our juvenile justice boards? Okay, we are asking juvenile justice boards to do preliminary assessment. How many mental health professionals are there sitting on the boards? Most of the time, we have one person who is going to be respect to the judges and lawyers in the room. We have magistrates who are coming with legal training. Okay? And we are asking them to understand the nuances of mental health, the nuances of mental capacity, which I think is observed, to say the least. Secondly, we also as members, how we across the I'm sure everyone must have done some study. What really is the composition of our boards? How many mental health professionals do we have on the boards who can do this? And thirdly, yes, we are very privileged in Bangalore to have NIMHANS in the backyard and say, no, we decided for mental health assessment expert who will come up. But who really, apart from cities like Bangalore, Mumbai, or Bangalore, who are these people who are writing these expert reports? We are having a lay counselor, we are having somebody who has done some counseling course somewhere, and they are the ones who are giving these heavy duty reports on which the JJ boards are making decisions that are going to change the entire trajectory of a child's life and sending them to an adult system to be treated like a child, be sentenced like a child. There is no looking back from it. So, to my mind, I think it's an absolutely it is high time statements. I think that section should go. It should never have existed in the first place. But now that it has existed for 10 years, I think it's a serious time to review it and say what is this done for children in our country? What is the data saying? As you know, one has had some things that we say, 10 years back, the same people, the same fights, we're just growing older, okay? But some things are not changing for the children in our country. So what is introducing this section 15 clause? Has safety from you, have reached someone, have changed what putting involved in that. What has changed? What has changed because of this section 15? Very little, very little. And therefore, for me, section 15 is problematic every year, not to do that. I wish there was a gentler way of saying it, but there isn't. Thank you, Kalpana. You touched on several aspects, but one thing that deeply strikes me is how unique this term because it's infusing mental health professionals into this role of not providing temporary treatment, but being part of something that none of us ever expected, which is a legal assessment, which has judicial and legal consequences for the child. So my question to Cathy is from the mental health professional perspective. So how do you view the role of the MHP in this case as supporting the JJB and how does this affect the child? Because as Swagata said, sometimes they are violent and they do the legal states. And if MHP is going to use secondary languages, you can tell me anything you want. This is a safe space, which is what we usually encourage MHPs to do. But here there are very extreme consequences that I know. So how do you view the mental health practitioner here? And how do we ensure that the legal states are kept in mind by both parties and so that to not further compromise the rights of the child? Giving a more for a fight to share that very very well spoke for me as well. Coming from a part of what is mental health professionals role in this section 15 counseling. I know that we got a lot of open debates between the mental health professionals itself. What do we do? Where do we start? Exactly the mental capacity. How do we assess the mental capacity of a child who is developmentally different every day? And the child is growing every day. And that brought a lot of discussion. But again, keeping in mind that it is there. So when we had discussions of how we move forward with this essay, is the role of the mental health assessment per se, the psychosocial mental health assessment per se, which adds on to the preliminary assessment report, which assists in that. In terms of that, as Nama's mentioned, I think our role is largely to understand the story behind the child, the pathway which led the child to this. More and more socio-ecological framework, which many times goes missed out, and also understanding the child from vulnerability, pathological and consequence framework. Vulnerability as in as an individual, what is the vulnerability the child holds? Probably the child holds an intellectual disability, probably the child has any temperamental difficulties or family difficulties, family dropouts, school dropouts, family marital response in the family, parental response in the family, history of abuse in the family. So what has been the history, in what environment the child grew up. So understanding that and also adding on to the pathological part. Is there any diagnosable issues in the child? ADHD, one common factor behind issue, substance use. So all of these also I think largely influence for the child to be in that circumstance. And the last part is of the consequence. As part of the mental health assessment report which we do in NIMHANS, we have a well-prepared assessment report where we discuss the child's version also. Just to tell what the child has to tell about what is happening and what is the process. What is if in case it could be self-implementing, but we should also open up about what is my motivation to change, what are the skills which is required for me to do better in future. We also have the part of having a previous test, which I was thinking that some part of their unconscious mind is to their motivation or what they want to do. So these are all part of the integrated assessment which we have. Then along with that, moving on to the next question of therapeutic interaction and legal interaction. It's a very fine line to having therapeutic interaction. Though it is a legal interview, I would strongly believe I'm still interviewing a child. So definitely I have to be trauma informed. I will not be completely crime center, completely whatever the child is telling. I'm going to be extremely validating that might not be a mistake. But I am going to be trauma informed when I'm discussing with the child. At the same time, I'm not going to assume like 100% confidentiality. I will have to, clearly define my role here. What is my role here? I am so and so, I'm part of this team, and you are not here for these things. So I think before all of that, when a child comes, the first question you would ask the child is, do you know why you have come here? Many oftentimes we can answer that, come to the road, they sent us here for check-up, physical check-up, doctor check-up, or they might not know mental health aspect for doctor checkup. So I think consent per se for the child to come to the hospital is a very institutional process. It's a very what to say? It's a flow. It's not just they come to the hospital and then it happens. It's a very consistent process. It starts right from the first picking up, to being the road, to being an institution, and then coming to medical institution. It requires a lot of training to be trained. I would call it more of a psycho-legal assistant rather than a purely legal or forensic assistant, considering that we're dealing with a child. I think that. If I can just follow up, so how do these children know what will be the consequences of this session with you? I mean, do they understand the way what being sent for counselling or for therapy, but they understand that an assessment will be made? I think many of them what happens here is they are actually quite scared to talk. So they see us as a legal talk. Anything which I tell here is going to go against. So child might not know anything. They might not even reveal their vulnerabilities also. If they school dropout or even the details about being try to understand your relationship. You have some happy friends. Did you have? Do you have somebody older than you? So even these questions they are very reluctant to answer with the fear that anything which I tell out might go against me. I think it's also a responsibility for mental health professional also to clarify their role here. They're asking few questions as a mental health assessment report, and this will be submitted to the board. And this is to understand what the vulnerabilities you come from and how we can support you further in terms of your vocation or in further of your support, in further of your restorative practices. But many of the time, I don't think so. Children get that they're often in a state of fear, so they quite dominant when they're in the discussions with you. Even if the child is okay, they are understanding. Parents, they learn the parents. If the parents are company, they are little more guarded and they might not let the child talk about the instances which might be of help to them. Thank you, Cathy. If you can take a step back and see this process from the eyes of the CICL. So, Amaidhi, I want to ask you, you did try to provide legal and other forms of support to children, including children who are state-based preliminary assessment. So, what is the perspective you can share from what they know about the system and what are the challenges that they are facing? Good evening, everyone. As Roshini had already mentioned, we have a help desk. The National also has a help desk at the observation hall in Bangalore. So we interact with CICL on a daily basis, and we also taken up quite a few of PA cases. So first of all, I want to point out that these are not just any children that we are evaluating. We are evaluating the most vulnerable children. As everyone knows, the children who are come into the system come from very vulnerable backgrounds. So many of them have not had, the support or the family support or other support like other children. So they are already very vulnerable. And when they enter the system, they are re-traumatized, and the PA is another way, re-traumatization. One more thing I'd like to point out is when the PA is done by the digital professionals, that is specifically in Bangalore, it is a PA report. It is not a recommendation as to what should happen with the child in the case. So, ADPs need to be trained and to see that it's just assessment. It's not a recommendation saying, okay, now the child has to be treated as an adult. So that is something we think is really need to be trained, on the PA system itself. Sorry, PA process. Another thing is, as Swagata had mentioned, the lawyers also are not really aware about the PA process. When we did a training for DLSA lawyers, they requested that they said, please tell us more about this PA process. How do we raise objections? And Swagata was saying that sometimes the PA report is not given to the lawyers or the children. So how do they raise objections? The prosecutor also needs to be trained on how the PA should be objections can be made, and so basically all around training specifically on PA needs to be done. I can give you some real life examples. We went to a couple of districts, I'm not going to name the district, but we did an audit in various districts, and as Dr. Kalpana was saying, at least in Bangalore, we have some access to mental health professionals, but in many of the smaller districts, they don't. And the members are lawyers on the board. And so there's a lawyer who's doing the assessment. And then when I asked the lawyer, but how do you assess this child? And she was like, what's there? We have to do it, we do it. And most of these children are moved to the children's board. And again, this is also with regard to tendency, because they're like, oh, it's somebody else's problem now. So we've seen a lot of these cases, and also with the PA, as the lawyers are not advocating for the children, there's a huge delay. So there was this one case when, it was an essential boxer case. The couple with their young baby has come 3 years later, still waiting for the kids. So the board was pregnant, and so there was a family to the board, and the board was charged with a heinous case. 3 years later, the couple added a baby had come, and the case is still going on, waiting for the PA report. Finally, we followed up with NIMHANS, it was lost somewhere, and somehow got the case closed. So there is a lot of delay as well due to PA. Some of the districts also, the districts, they don't deny it, but they postpone it. They say, we wait for the PA report now. So many times, a lot of these consensual cases happen. They can start with teaching students. Like we know of students who missed the whole year because they could not write exams because they're waiting for the PA report. So I think everybody has said it is very detrimental to the child, and I also as a guardian selfless, we don't see the sense in having PA, and as we know, I think there are some data that 80 or more percent of the cases are the residential cases. So why do we even have this, yes. Thank you, Amaidhi. I do want to get into more of what you mentioned about the PA report. So from what we are seeing, we are also seeing that just because the term that is used for a PA report, which is actually the report the mental health practitioner, and some of them are making recommendations also the law, although the law just says that you can take the assistance of experts in making this determination, but the final determination does rest with the JJB. But we are seeing confusion all around for it, and we're also seeing some districts that they set up a board of mental health practitioners for a mental health, for a PA committee, which will provide support. So, from the perspective of the JJB, so how are JJBs viewing this report? And especially when reports are gone above and beyond its scope. So, what are the implications to the child, and what is the JJB? How is the JJB looking at this? Multiple levels of complexity. To start with the very nomenclature, the naming message. I think just calling this report a preliminary assessment report is wrong. The preliminary assessment, according to my understanding of section 15, is to be done by the JJ boards, not by the mental health profession. So I don't think, so that report very clear. Preliminary assessment report is a report which will be made by the Juvenile Justice Board, which is for the sole purpose of saying, is this child to be tried as a child or to be sent as a man. That's all. So therefore, in fact, this itself used to cause a lot of interesting debates and public debate. Because I would insist on writing in that policy expert report from mental health profession. I would refuse to call it the preliminary assessment report because I believe preliminary assessment report is a report which the jail goes to, not a mental health profession. So that at least to start with it should be done. So call it what to call it a counseling report, call it a preliminary assessment. Specifically, the force to make that determination is very clearly in the law. That's the first. Secondly, like Amaidhi was saying, I find it bordering on the absurd that a lawyer should be making a mental health assessments, their psychological assessments. They simply not qualified to do so. Yes, I see merit in that what Amaidhi was saying, that there are some disputes. I see merit in having a multidisciplinary team. So, for example, the reason why I would place a lot of value in the report that comes to me from, say, the Department of Child and Adolescent Psychiatry is because I know there is a team of mental health professionals who look at this child. There is a psychiatrist, there is a psychiatric social worker, there is a counselor, there is a whatever. There is a whole team that's looking at it. More than one pair of eyes have looked at that, looked at the child, spoken to each other. There is value in that. Okay. So definitely I would think that having a team of mental health professionals for doing assessment, yes, makes sense. But one person, insufficiently trained person doing doing this assessment, these are things that I am unable to comprehend how that works through. Then this thing that because this is supposed to be a report that is supposed to assist the board in coming to a certain decision with what is the decision? One best interest of the child. I think somewhere we lose sight of that when that is what the Act first says. Let's look at the best interest of the child. Then we come to should we look at who should write it, what should we be doing about it. So to my mind, I think that mental health report, which comes just like the social investigation report, individual care plan, these are crucial documents that should help to inform the juvenile justice board in making decisions that are in the best interest of the child. And in that larger scheme of things, you are also as a board member also see that what is the nature of the offense and what should happen to this child in terms of informing your position, reintegration in society, which is what is the objectives of the change. So I would say that is where the focus should be. Right? That is where I would place. The other thing I wanted to also point out something that Cathy was saying and what Swagata said in terms of a problem in terms of the principles on which something is based. Just as there is a legal issue, I would say presumption of innocence. Here we directly jumping into presumption of guilt. You assume that the child is guilty and then you go on and ask questions. It's the principle of integration, clearly violating that because what is my mental health profession doing? Tell me what you did now. What are you doing? No, not acceptable. Right? And that is, to me, see the two very fundamental principles of mental health profession that are getting violated there and there. First is confidentiality. What happened to that? Once upon a time, you were trained in that, right? The first thing we learned as mental health professionals is confidentiality. What happened to that? Who has asked us to go and tell because JJ is asking and somebody is asking and somebody is asking what the child has told you? The child is trusting you, madam. The child is trusting you and saying, I did this, this is what is happening in my family. Confidentiality and that has a larger, I think, philosophical problem for the entire mental health community because here, when will our children ever trust us again with anything? If you are going to go and snitch on them, who was on Juvenile Justice Board or whoever else asks us to snitch on them. Okay? So to be one, that principle of confidentiality. The second was again for those of you who are non-judgmental. Whatever happened to non-judgmental?
Whatever happened to empathy? These are things that are at the heart and core of our practice principles as mental health professionals. And here, what are we doing? We are actually telling the child, come here, tell me everything, and I'm going to put it in a report, and I'm going to put it in a series, cover and go in signature. So, I mean, principally, ethically, that is wrong. That's completely wrong. And again, something that you said, we ask these questions, seemingly innocent questions. In fact, why did they tell you whether who's my friend? Because the police has asked me the same question, taken my friend again and once of questioning, and my friend is still in custody. So you know, the fourth adult who's going to ask me, tell me what's your friend. So that your friend can also get into trouble. What would I do? Why would I trust? So to me, these are not just sometimes these things that are written as protocols and guidelines that come. I think they violate certain fundamental values and ethics of whether it is a legal profession, whether it is a mental health profession. And I think that the responsibility there of the Juvenile Justice Board and of the professions who sit on that bench is therefore to be very clear about what ethical ground are we standing on. At the heart of it, we are here to serve the children. And how can we allow ourselves to forget that in the process of writing one report, in the process of giving one whatever? The third thing also, when Cathy was speaking, I was saying, as mental health professionals, we are trained in therapeutic interviewing. We are not trained in forensic interviewing. Okay? We have two national institutes, to my knowledge, and I may be wrong, which are fairly new in this country. One is in Gujarat and one is in Delhi. They have a course on forensics. And you need a particular kind of training to be able to do that forensic interview. Just asking somebody who's your friend, what does your sister do, does not make me a forensic interviewer. No. Okay? There has to be training in it, there has to be education in it, and we should have the skill being able to do it. And I am in Bangalore, if you don't have access to it, I will be completely wrong on this, and I know I wish somebody corrects me. But I don't know if anyone has made this kind of interviewing for expert reports that are coming from mental health professions. What is the kind of training that they have in even asking these questions? Right? And then, having these reports which have no basis for the board to then decide that, based on this report, we are going to, send this child off to be tried as an adult and sentenced as an adult. So I would think that there is a huge amount of responsibility that lies on the shoulders of the Juvenile Justice Boards, and to put it on that mental health profession, I think is not correct. And yet, because of the way the mindset is, and especially if you're going to have, there is a magistrate who's a principal, who's the chairperson of the board, you have lawyers as members. Then who are going to think that, this psychological report which is coming is, the hospital software has to be it is an important input. It cannot become the deciding basis for you to say this child should be sent to the, like any other report that is given, like the social background report that comes. Which not the social worker will write right at the beginning of the police station where the child is being brought. It's my social investigation report, which my social worker will do. Very important. So, like that, this expert report from the mental health profession, not the deciding document to decide that this child should be treated as a adult. Thanks, Kalpana. I want to stay with this numerous concerns that are being voiced regarding the report of the mental health profession. So, Amaidhi has also pointed out another aspect to this situation, which is the time gap. So, she has of course stated about the disruption it has on this child's education and career, but also coming in from the forensic aspect. Cathy, I want to ask you. So, it has Amaidhi says this report is being asked to be done sometimes months or years after the offense is allegedly taken place. So, how is a mental health practitioner who is doing this forensic role, how can they assess the mental capacity of the child without the offense? If such a significant time gap is already lapsed since the event, and also this child by the time will be exposed to the judicial system, you will be produced before the JJB, being apprehended by the police, and already spent some time in the observation home and being detained there, which all has impact on the mental space that the child is in. So how can the mental capacity be done retrospectively? See, I think straight away you can answer that is a limitation, and I think that's what we are debating over also. Thank you, ma'am, for talking about how because there's a lot of I bring that pressure. There's a lot of decisions taken based on this one report which is sent from NIMHANS per se, or thinking that as a global case is important. It has come from the pressure has come from the police, the pressure has come also from the parents. Sometimes this report don't write anything wrong. So there's so much into that. So I think we strictly know what we are up for. We are just up for a psychosocial and mental health assessment report of what is the understanding of the child and what was the child's background, what was the circumstances of the child, and how this report might help in the future respiratory practice. So that is the only role I think the report largely has to play, and it is just an assisting report to the primary assessment report which the board is doing. So, adding on to your question, Percy, yes, time limit is a huge challenge because many cases next week is a hearing and a week before they come, they want the report. That is not possible. One section, one report is not possible. For a child to open up and talk, which again is a very difficult thing, it requires a lot of legal challenges, a lot of legal challenges, as Mark spoke about. No child gives an informed consent. There is no form we are writing. If there was a chance, I don't think so any child would give consent. So it is procedural and the child knows it's procedural and they have no other way and they have to do it. And unfortunately, we are also playing with it. So that's how it is. Only that we can do is, in the section at least, we may not be labeling the child or we may not make it more dramatic for the child when you are having a discussion. Make it as much as not treating the child as a child who's a criminal, but it's treating the child as a normal child. Not seeing from the child who has done the activity, rather just seeing the child. So in terms of the time, I would not tell that we are not assessing a cross-sectionality. Cross-sectionality, yes, when the offense occurred, what was your understanding or what was your understanding for the consequences? But I am also looking at the longitudinal factors. So how was the child's development? How was the child brought up? What was the child's school background? What was the child's attachment with the parents? What developed the child as a personality? So I am looking at from a longitudinal background, and I think that is more important to understand the child, to understand where the child is coming from. It is not a cross-sectional assessment of this is what the child is, and likely the child has a full capacity, the child can be tried under children's books. That is not where coming from. They are coming from a longitudinal perspective, they are understanding all the vulnerabilities the child has to face and what was the circumstances the child did that. We are also keeping in mind, this is where the limitation comes, the child's mind keeps developing, the child is there in an institution, they speak to other inmates, they kind of get the socially appropriate language to speak also, right? So we cannot really rely completely on that's where the limitation. And also, one part to address this limitation is having collaborative information, having information from family, having information from school. So this again might lead to a process of consent, but anyway we will inform to the child that we will be talking to family, we will be talking to your school to get some more understanding, and there will be collaborative information which is already given by the group. So based on all of this is what the report is doing. Thanks, Cathy. So concerning some of the concerns that have been voiced here, Amaidhi, I would ask you how can effective legal representation help in ensuring that the rights of the child are maintained throughout this process? Then what is the role you see? Throughout the process as a yes, definitely. Uh, so effective, I mean, as we know that most, as I already mentioned, most of the children come from vulnerable backgrounds and they don't have access to, efficient legal services. And we do have the NLSIU learners who represent the children for free. But a lot of training needs to be given, specifically on PA. As I mentioned earlier, many of them actually came to us asking us, can you help us with understanding how the PA process is done? Also, one thing I want to mention is I think I get the feeling that the entire system, they don't get the gravity of the speed. I mean, this is a child and you are sentencing this child to 20 years as an adult rather than 3 years of rehabilitation. And even in the children's court, they are supposed to have follow-up and rehabilitation. But as we know, our system does not have the capacity to do this, to get children between 6 and 18. It very rarely has the capacity to do it for any of the children that enter the system. So definitely one of the main things is if you have, and another thing that I have noticed in our 3.5 years of running the helpless is I have never ever seen a child from a privileged background in the observation home or at the GG. It's always the parents who come. If there are one or two cases, the parents who come and they have to file a PPA, the child is never there because of school or because of thing. So first of all, most of the children are from economically and socially impoverished backgrounds, right? So it is, I mean, I don't know how to answer this question to be honest, because it is a whole systematic failure of, I think the best way is, I would say, it's divesting but diversion. Like, don't even let these children enter the system, that's the way you can protect their rights. But once they enter the system, yes, we need to have good lawyers, we need to have really good training for lawyers, for taking for the children's court. And I don't think some of the cases when we attended the children's court, they are not familiar with the JTI. And they don't understand child parenting procedures. They already see this child as an adult. So it's not just the JTI that needs training, but also the children's court. And also we really need to focus on follow-up and rehabilitation. So it's a huge, it's overwhelming, but yeah, that's perfect. Thank you, Amaidhi. I now want to get back to what happens within the GGB. So we understand that transferring a child is not easy, and it's a complex and possesses huge implications for the child that is involved. So what happens when there's a difference in opinion within the GGB itself? How does this work? And how to use the words resolved basic sentences. What happens is usually not resolved. The problem doesn't get resolved. I have the dubious distinction of writing the most number of dissents to the Juvenile Justice Board for the 7 years that I was there. And my dissents have largely been for two specific things. One is for bail and the other is for transfer. Otherwise, I would like to believe that I'm a fairly reasonable human who likes to arrive at consensus and resolve things. But these are two things that I could not reconcile in my head, and therefore dissent. Dissent, I think, is something that is how, at least in my JGB, was the way in which I tried to resolve it. Bail, again, I would say dissent at the stage of bail. It's very important to understand what are the circumstances under which bail is being granted or rejected to a child in conflict with the law. And on the one hand, yes, we have this ideological, stance that liberty is the first one. Bail is like us, the bail is the rule and jail is the exception kind of thing. And I completely believe in that. And yet we must be very mindful especially in the context of an Amaidhi because we had children, especially in POCSO cases, boys who are denied bail merely because they are coming under the they charged under POCSO. And these are two children, and I am speaking specifically of the cases where there is romantic involvement, and this is not really a case of child sexual abuse in the way that we define child sexual abuse. These are teenagers, adolescents who are having romantic feelings for each other. And yet, we say POCSO is a gender neutral law, and I hope that I wish it was. But in reality, how that plays out is if you're a boy, you will reach before, you will land up before the Juvenile Justice Board, and you will be kept in, detention. So we don't like that word, but yeah, we like to call it institution, a child care institution. There is nothing like called care in a child care or any institution setting. If you're a girl, you will be sent for counselling to the child welfare committee. Right? And yet, these are the boys who will land up becoming children in conflict with the law and stay here, and these are the children for whom bail will be denied. And I have had children, and in my own community, in my own board, whose bail was denied for not just days or weeks or months, but years. And I know overriding dissent after dissent, fighting against those laws. Right? And that is where this question that Swagata spoke about legal representation for children in conflict becomes so crucial and critical. Because if we leave it to the free legal aid lawyers that we are getting from the Karnataka State Legal Services Authority, yeah. If we have to leave it to them, then God save our children. Because that, there is, I don't know if that actually qualifies as legal representation. Legal presence of a lawyer is not legal representation. We need lawyers who will actually fight, who will represent, who will argue, who will give written arguments or local arguments and say, this is what we believe in. But that is not what happens in the courts. Right? So the quality of that legal representation is crucial for children in conflict with law, especially given the fact that overwhelming majority of them are from families and backgrounds who cannot afford another private lawyer. So there is that. Then, of course, the actual question of dissent for transfers. You heard my views on transfer. So there has never been a case where I felt, oh, this is a fit case for transfer into an adult court. I haven't yet seen a child who's beyond reform or rehabilitation or redemption of some kind. Okay? I think at the very heart of the Juvenile Justice Act, it says we are here to see what went wrong with this child, how we as a society fail this child. Okay? And if that is what we as Juvenile Justice Boards are sitting there for, how can it become alright that we sit here and we say you go to that very adult system? There's a reason why it's called the criminal adult justice system. Right? If you just think of the word criminal as an adjective, we understand it. Right? We understand it better. So this is not a case for children deserve and they are entitled to. Right? That is why we have a separate law, a separate legislation, a separate juvenile justice system for children. After we create this elaborate system which says this is for children, what we sit and do, we say let's have an you. We try and treat it as adults. And therefore there is something that is inherently and fundamentally wrong. And which is what I've tried to say in multiple ways in the multiple dissents that I've written over the last many years. So yes, there are some boards which some of my colleagues which disagree more vehemently than the others. But I think it's very important. And the other point that Amaidhi was making that even the training of whether it is the training of our judges, whether it is the training of our boards, very important to train and trained on the process of writing orders, writing effective orders, reasoned orders. Be okay with saying that no, this is not all right. Right? And that I think sometimes is also, it's not part of our training at all. So how do you, it's not just about giving them best interest, it's about writing that in a way that can be challenged in a higher level. In a way that child goes on appeal using this order, they should be able to use that and fight it in a higher court and be able to win. Right? So to me, those are equally important, crucial aspects of your role on that team. Your three people, if you don't agree with, I wouldn't just give up something this easily if it was our child. Each of us sitting in this room and we look for a school that our child has to join, a college that our child has to go in, some hostel, something. Is it that easy? We just agree to everything that everybody sees. Don't we make that effort to say, no, this is not good for my child. Don't we speak up and say, no, I think my child won't be happy. No, I think my child won't learn good. But because it is that child who comes from, a background of total impoverishment, who doesn't have anybody to fight for them, who doesn't have a lawyer who's going to speak for them, lawyers who don't turn up except for, saying, madam, attendance and sign body, attendance, or claim our report. Other than that, I don't think we will be so easy or, quick in just agreeing or complying with things we are not okay. And I think that has to become part of training for judges, training for courts. Thank you, Kalpana. I now want to get into the last question of the day before we open up to the audience. So, I have a two-part question for you. So, we have spoken so much about legal representation and now we have audio of judgments in the higher education. Can you tell us when has been legal representation that has been effective? How has the trajectory of that case really shifted? From where it was getting to where it is now. That is one. And secondly, if we can step back from the problems that we are seeing with the implementation of the council system by looking at just the design as a whole, does this align with the international legal norms and standards that are seen? And you have to understand that the council system, which is called a waiver system by different nomenclatures in the world, what has been the experience of other countries, and is it some wisdom that we have from legal systems that have already introduced this kind of much longer duration of experience in the system? I think when we look at what the role of the Indian judiciary has been, the Indian judiciary has actually shaped juvenile justice as we understand it today. Basically, in 2015, 2025. But if we go back, in the 1920s and then, with the Supreme Court coming in the 1970s and 80s, juvenile justice is really a product of the Supreme Court. Where, Justice Krishna in the 1970s said correction informed by compassion, not incarceration leading to degeneration is the objective of the law. So I want to put that out. And if you look at who is responsible for the kind of critical legal issues on which we are getting clarity from the courts, and what are the kinds of cases in which this is emerging, it's no surprise that it comes from Mercedes Hinton case. It takes a Mercedes Hinton case to reach the Supreme Court for us to know what a heinous offence is. It's not the cases that are languishing in observation home in many parts of this country where those children have never had access to the lawyers who will go and question the most fundamental violations that take place on a daily basis. It's another case of of this unfortunate case of a young boy who was killed in the bathroom in a school in Gurgaon. So, it's important to pay attention to the kind of cases that reach the Supreme Court. It's families, yes, their children have been involved in an offense, but it's also families with the means to hire the best legal representation that can take up these arguments in the Supreme Court of India. Having said that, I also want to clarify that so much of it depends on the subjectivity of the judicial system itself. So yes, with all good intention, writing a report may be written, it is beyond your control once it leaves your desk. You do not know how that entity is going to interpret what you are writing in terms of the vulnerability of the child, or whether the child has mental disorder, does not have mental disorder. because of the analysis that we have done, we are able to see it pretty much doesn't matter what you write. That child is anyway going to get transferred. So whether the child has been to school, has dropped out of school, if he's dropped out of school, he's worldly wise, so he has capacity. If he's been to school, he's smart enough to go to school. So you see, you don't win either way. If you say that he has, he has no mental, he's average intelligence. He has average intelligence. He's but in the larger scheme of things, nothing shifts. If anything, there's a negative shift in the life of the child. Just to add one more judgment, which is now gone to the Supreme Court, this is the second stage of the PA process, which is, you've been tried as an adult, now comes the stage where you are going to be evaluated whether you have reformed or not. And here's the case in Chhattisgarh where this boy has spent a good number of years in the case of safety. The probation officer's report is excellent, saying that this boy has participated positively in all activities. He has really shown, a lot of promise. He wants to go out and, invest in sports. All of this is good. And what does the court do? The court says, no, sorry, we cannot release you. And this goes up to the High Court. And the High Court uses the absence of support mechanisms in the community, in the system, to say we don't have good probation officers. We don't have people who can follow up with you. We know that the community is going to be hard for you. Therefore, we are not convinced that once you go out, you will not reoffend. It's your fault. It's your fault. It's too much the system outside doesn't work. So, to protect you from yourself, he will send you to jail. And this is now before the Supreme Court. The Supreme Court has said that this judgment is not to be considered incident. But yes, just to say, the courts are the only doors that we can knock on for justice, but sometimes it depends on who's sitting on that bench. Coming to examples from the other parts of the world, the US is a leader in this. Maximum number of children in prison. We don't look anywhere else. They're the leaders in this, and there is so much evidence that comes from the US which tells us that it has not worked. You have created so many juvenile prisons. There is a school to prison pipeline. There is a juvenile detention center to prison pipeline. Nobody is safer than they were before. Instead, your reoffense rate goes up because the child is being exposed to, the fears of the child are all people who committed, for no heinous offences. That doesn't work. Instead, what works is community-based intervention. So invest in that. That's much more cheaper, and that will give you more long-term benefits. Also, 3 countries that have changed the age of, at which you can get access to juvenile justice benefits and safeguards. Germany, Croatia, and Netherlands. So Germany and Croatia have looked at neuroscience. It's interesting how none of you brought in neuroscience. But Germany and Croatia and Netherlands have looked at neuroscience, which says that the adolescent brain continues to develop in the age of mid-20s. So why not extend? So they have extended juvenile justice to 21, and Netherlands has got further extended to 23. So when countries have looked at science in a way to extend safeguards, we have looked at science and said, doesn't matter, let us lower it. In fact, bus is too high. There have been also conversations saying that if it's 14, 13, your age doesn't matter. The offense itself should define whether or not you enter the justice. Thank you so much, Jonathan. That is very unique, but we are continuing the conversation. I will now open the floor. We are now volunteers, Amaidhi and Raha, who are going to pass on the mic. So, request you to raise your hand and call upon so I think let's start with the speaker question. Yes, sir.
It's a strange coincidence. I saw the movie The Court and it's a special history. So I think that is discussed is valid. There was an innocent boy and a girl that gets to him. And there was a time when his father comes to dinner and they don't want father to know that the girl is unknown very sick at home. She sits inside. And the time boys they are from an upper in terms of financial status higher. And so there is a lot of false accusation on this boy. And finally a lawyer, junior lawyer falls. unless so. I think all that can discuss
Yes. So, in 2019, in the context of the release of the research study titled Why Was Generating Value, Justice Law had also going to consider the reducing the age of consent from 18 to 16, and others I could also agree and suggested this. So, in the context of reducing the age of consent from 18 to 16, how would that affect the legal process, and how would that affect the treatment of those adults within the juvenile system, and how would the conflict resolve? Any other process? Hi, my name is Amaidhi. I'm a counseling psychologist and currently I'm also a scholar in heinous and graduate from each diploma. So I have 4 questions. I have 1 question for each. So if I can just read out the questions and then you can take your time and answer accordingly. So to Kalpana ma'am, you were talking about how there's no scientific or neuroscientific basis to assessing if a person is committing a crime. We start by saying that anybody is capable of committing a crime. I think it was so coincidentally Swagata ma'am brought up that study that she started talking about in the end. So in reference to that, I wanted to understand when you were talking about assessment and the questioning, who are we assessing, how are we assessing? If we are going to look at it in a very structured format, what is the reference that we're using to assess? Because again, we talked about the child and circumstance and all of that. But then ultimately it is, I feel, my view is it comes from the bias of the members. So what is the reference? That is something I want to ask. My question to Ms. Cathy is when you were referring to the assessment of the child, right, the community assessment, you gave different viewpoints relating at vulnerability and understanding the pathway to child, sociologically, all of that. And then you did mention about the pathology of the child, whether it is diagnosable or not. So currently in India, because we still, developing in terms of psychiatric and understanding of health as a whole, I think it takes a long, it's a very tedious process to diagnose someone and kind of give a label. So when you're looking at the treatment, again, scientifically development team, even diagnosis seems like a very tricky word to use. So when we were talking about the pathology, considering that people are not as trained to interpret it in the right way, what do you mean by diagnosis? What is it that you are looking at as a psychiatric social worker from the psychiatric mainstream? Question to Amaidhi ma'am. You were referring to the integration of the psycho-legal approach to play. So I wanted to understand, based on your experience and understanding, what is your suggestion? What is your ideal approach which has the benefit of both? Because this is something constantly I would see that there was a shift between the legal and the psychological. So I am trying to understand when you look at it, what is your ideal image of the two come together for anybody who is dealing with this semester? And Swagata, my question is, because you are with Enfold, I was thinking of understanding what psychological representation a support person means. This again, it doesn't have to be a psychologist or a legal person, but even when we are talking about a lay person or a family member, because considering again, when we are looking at children, they are treated as cases, which is a file and all the information is there. From one place to another, information is sent out. But then we are considering the adult who is accompanying the child. What is their role? How does it look like for them to be present from point A to point Z, and what is the competency that we need to have in order to do that, so-called focus. Thank you so much.
So I think can you introduce yourself first?
I don't think that education is already known. Anyway, that's what the ideas and so on for evidence is. I think the smart action in the officer can be traffic is what I'm asking for advice now from 2000 to 2015, it was 15 years. In the Act of 2004, we had a system. Now has any change been brought? Forget about the language of section 15 and 6. And as most of you know, but for the two intervening petitions that were filed in the Supreme Court, the entire case was going on, where Subrahmanya Swami is very fine, these things would not happen. Supreme Court did not agree with their contention, we maintained it should be considered. Now the act was amended somewhere and was completed. Now you have done a good type of research. Has this really brought about any change? Before 2011, 2015, this act came to force. Before that date also, between 2000 and 2015, for nearly 50 years, we had that, 50 years we had that act. Children were being tried by JJ. Even when the act only happens certain and 376. What is it that has done? Has it really served its purpose? Is it not possible for us to forget about the two officers' rights and decide can you not suggest something through a proper agency? Based on some research and strategies, this has really not served purpose. Ultimately, Parliament is not under control. Can you not do something little on that side to see that this is really not working? And secondly, that section 50 does not just contemplate with assessment of mental capacity, physical capacity also. I don't think that any doctor other than mental health persons are involved in this assessment. Maybe by common sense, they say, alright, he is able to go relax, he is able to do some other efforts, but that is not being done. Maybe I am not working in the jail, but occasion to be. This is one thing which needs to be examined. Now, of course, you know the statement of the Supreme Court, section 15 has been held to be mandated. Necessarily, we need to have the preliminary assessment done by experts here. Treatment. But even then, if it doesn't really serve any purpose, as she would have put it, incident has taken place 3 or 4 years back. What was the physical capacity, of course, maybe to be able to assess. But what was the mental capacity? How difficult it is? Who is to tell the circumstances? The animals may have, training after, who will care about it? And I don't think that the neighbors will be interested in working about the circumstances. If it has really not worked, not served any purpose, well, is it not possible for us to make some recommendation to proper training to see that it is not really working? Because anyway, you have a lot of inputs from other states also. This is not what I wanted to say.
Good evening, everyone. I am now Director of Karnataka Judicial Academy. Very interesting, very interesting discussion, and I'm lucky to be a part of it. My only view is that insofar as Dr. Kalpana's statement that JCB should be trained in writing effective and recent orders. See, you were mentioning that you have a lot of dissents with regard to bail and transfers. See, it's in a way one appreciates the report. So my mindset needs to be changed. Apart from the writing, they may justify granting bail or not granting bail, or transfer or not transfer by way of an effective order and a recent order. Probably to view things in the direction you want the JJBs to work on. Proper training is required, I agree. And with regard to what Social Officer was just mentioning, that this preliminary assessment report, as rightly put by him, physical capacity also needs to be looked at. And the mental condition or mental condition of the child in conflict with law at the time of commission of offense is assessed at a later date, which is really not fathomable and acceptable. Probably the whole system has to work towards this to get the reports on time so that JJBs really work well and pass effective orders. This is fine. Thank you.
Last question. Ali?
Yeah, I'm one of Enfold. Today all of you here today, and I think many of us in this room will be part of many research processes, process on the today, I think you have an excellent job in summarizing what Section 15 has done to discipline the environment with children. And really what Swagata said, what is it that can be done? I was wondering that despite the fact that the Supreme Court has said that the PA is essential and it's peer reports to do that, can you imagine our country if every junior social worker, every junior psychologist and psychiatrist will stand up and say, in your words, Cathy, I am not going to play this game. I'm not going to play this game. So if you're not going to have the experts in these reports, then the owners will be on the Juvenile Justice Board members themselves, because that's what they like to do. So then, would it be the members of this board who are appointed in this, to play this role as a judicial, passing these value orders? What is the ethical model? We want to use words that are outstanding. We can understand. 10 years have passed. Now, whatever advocacy we may be doing in terms of challenging this to a constitutional challenge, whatever that these are strategies that perhaps we keep about slowly setting. But I'm just asking, as institutions and as professionals, is it not possible to start some kind of campaigns where as professional association, social workers, professional association of psychologists, they refuse to be part of this game? It's just a suggestion. And one of the questions perhaps they have to perhaps set a solution that is absolutely essential as we complete the exercise.
And let's start with the answers. Swagata, you can start with the age of consent. We'll come back to this. Yeah, I'll start with the most provocative one that Swagata sir has put out there. I think we can keep talking about the number of trainings that we can have to strengthen. The question really isn't, do we want to improve this, strengthen this, and how do we do this? That's not the question they're asking. And the question they're asking is this serving justice in any way? If we are challenging the foundation of the system, we can find ways of helping the right orders and have them consider your inputs. It is not about that. Right. The preliminary assessment only. I'm talking about only the preliminary assessment process. Exactly. So of course, I think there is a lot of groundwork that is underway to challenge the constitutionality of the provision. And all of this research, these conversations are a step in that direction. And incidentally, sir, we were actually part of Subramanian's story. So we had intervened, we were at the Center for Child and Law, we had intervened in the matter and presented a report that, is very much within the right to equality for those below 18 to be treated as children in conflict. So that is one. I'll come to your question. I think to ask, support person for a child in conflict. That's like a glaring omission in the system. We have not even recognized that a child in conflict the law also needs support. So when it comes to a child victim, we still have systems in place, but a child in conflict the law is navigating this entire system without any support. So we need to think of institutionalizing a support person mechanism even for a child in conflict. The system is so hostile and brutal. There's no one standing by the side of the family. They don't know. Many times they are told that if you go to NIMHANS, we get bail only if they give you a good report. That's the information they have. So they think it's for, or they think that you go and tell them you want to study, they will get school admission. These are things that children themselves have told us. These are things that doctors have told us. Children come thinking that, you give the report, I get bail. That's how little they know about the system. I think your question question about 16 to 18 and how do we reconcile our positions, because I think some of us here have a very strong position that when it comes to POCSO, we need to recognize consent for those who are above 16. And in my mind, there is no contradiction between us saying this and saying that all children in under the law who are below the age of 18 need to be treated as children. Because we have to look at the purpose of the law. If the purpose of the law under juvenile justice is rehabilitation and reintegration, how are we ensuring that by saying that you will be deprived of this based on your offense at your age? So you are treating me at a disadvantage. You are taking rights away from me. And then you think this is a Juvenile Justice Act that is made for my rehabilitation. Now flip it for POCSO. So POCSO is to protect me from sexual offences. But here I am telling you, I only forced him to run away with me. And I want to be with him because my parents are arranging my marriage. To protect me from my own self, you will institutionalize me. So we're looking at criminalization to protect children and advance their rehabilitation, and the answer to both is it doesn't make sense. So you have to look at what the context of the law is. It's not like 18 means 18 blindly and we will not recognize that those 18 have capacity for certain things. Law already does that. Why is it that you are allowed to work when you're 14? Why is it that you can give an oath when you're 12 and above? Why is it that you can give medical consent for medical processes when you're 12 and above? So the law already recognizes that you have capacity. It's not that if you're below 18 you have no capacity for certain things. How can we make it in a more nuanced way?
I just want to proceed to what Sunani raised in terms of the psychological assessments. Without going too much into the technicalities of it. See, a mental health professional will need certain psychological assessments in terms of certain tests. These are standardized, these are known, and these are known to work in the same way with a certain population. So they could be in the terms of, say, IQ testing, or some of those. Or as a mental health professional, I can speak and tell you what is the mental health status of this child. Or I can tell you, does the child suffer from any disability or what? I can tell you that. Or from the child, triangulating with the parent, with the family, what was the child's health history? Those are things I can tell you. But what was the child thinking 2 months before, 4 months before, when he went off? These professionals are not asked to talk. We are professionals who are trained to do certain things. Right? We cannot go into the past, into the head of somebody, or go into the future. Yeah. Yes. So these are specific tools that a mental health professional will be trained into do. And the purpose of that is to understand what is the mental health status of this child, and therefore what should we do to help this child, even if it is including for diagnostic purposes. It is not to say, should we send this child to an adult court or not? That is not the purpose of that psychological test. That is what I am trying to tell. Right? That is not what the test has been designed for. And nor are the people who are administering that test be trained to administer it for that function. So these tests are administered for the purpose of saying, do you have a mental illness, do you have a mental disability, do you have a problem, what would in childhood if something happened to you, what can we do now to help you? That is the purpose of this test. Not to say, should you go and stand before an adult court or not. Social approach to the and I think we said it. Psychological approach. So I mean, everyone said this, and I'll say it again, but I think PPA is very problematic. And in the JJ Act also, it says that the section 15 says that the JJB may take the help of a medical professional in the field. So as long as we start with the athletes, you said that we will get rid of this one day. But as long as we start with this, I think at least that should be mandated. That it should not. So we did interviews across the state, and many JJBs interpret this as
it's not mandated. They may or may not take it. So at least in the interim, that KJPs should and must take the help of mental health professionals for the team. And also again, like all the parents have been saying, CICLs are also children in need of care and protection, CICL. So we definitely need a support system, to help them with PA and other processes to help them navigate the juvenile justice system. So we need to look at it as together. We can't just look at psychosocial separation and clinical separation. We need to look at them together.
Answering the ma'am, I think the man just was that at least again talks to the Department of Psychiatric will be here. There were some legal documents to come for observations per se. We have meetings where we written back to them where there is no clarity, especially in terms of what is our role as a part of section, how the role is stated. We need more explanations on it. What do they really mean by mental capacity and what are the other things? So I think we have responded on a legal aspect. I think more of a social action perspective definitely that could be taken up. Answering keeping in mind the child's developmental perspective, we completely agree the frontal awareness completely in development, all the rational decisions the child's make, child's intellectual abilities, the child's impulse control, everything is based on the prefrontal cortex, which is still in development. So the child, when they do something, it's more of a dependence towards the amygdala, which is totally with the emotional perspective. So this is when we consider the child who's doing offense. But when we diagnose as might conflict what we said, it's exactly in terms of child psychiatry in India, it's quite well developed, and we have ICD, we have a particular criteria of when we diagnose a child, especially for child who's having neurodevelopmental disorders, for example, IDD, autism, ADHD. These are quite evident, and we have standard measures to whether this child has a diagnostic condition. And again, a child is diagnosed not to label, a child is diagnosed so that the child gets the adequate help. That is why we don't know where the mental health report is going. We give the report and after that nobody shows up for follow-up. So what is our role there? Are we just there to give the report? We are not able to. Who should follow up with this child? We don't know anything which is happening after the report is due. So the family bringing the child back, the legal system or the system, correction system is taking the efforts to bring the child back, to get the efforts the child might require in order to, in case if the child has some legal offense also, in order to prevent recidivism, in order to have a healthy development of life. So what as a system we are doing is something we need to consider. For more questions.
Good morning, I'm Roshan from Bangalore. I have been working with support as well as with the police. From the point of the child was found, who brought to the police station and police before they even the officers, the power. See, the main area will be routine. The child found in some way, the plot by someone, the police someone else, and doing somebody follow. One miss. So after few years or after few months, we are not very sure that what is the condition of the particular child. So in this way, how shall we convergently can do a measure, for example, being the child in the family, with the consent, maybe the children who are coming before JJ, we are aware that the dysfunctional families, the economically soundness, nobody is there, and nobody is found, nobody is supported. So for that case, how shall we contributing stay as a child from the point of first point till the JJ board? After even though we collected the social background report, social investigation report, psychological social report, the counseling report, so many reports we have, and again and again we asking why you are here, what is the purpose? So whether we are surviving the purpose or we are taking in the testing of the child. And we say the state is that any child before the JJ board even the children in their conflict. So they have the rights. They have the rights to
about from the what negative experience or whatever it may be. So therefore, how shall we track the child for the welfare and the betterment and reintegration of the society through maybe community service or some concepts. So our ultimate is supposed to be the best interest of the child, any kind of offences the child made. So how shall we convergently do with the certain level of policy or something to address the areas of the issues of the especially 16 to 18 is a major concept. I think this one I asked Swagata because he's visiting all the districts in our states in some of this. How do you feel about this section?
Hello everyone, I'm Dunya. I'm a child medical professional in the pharmacy agency member in Bangalore, urban district. I've always had a problem with section 15 from HSC, and as Dr. Kalpana said, there's nothing beyond about it, and it's the most important. We always talk about in GT, we have a lot of references to psychosocial support, or psychosocial assessment. I sometimes find it very funny that it was put there because there's nothing social about it, right? When you're seeing or doing the child's assessment, eventually it is psychological, right? You're just giving a report that a psych expert is giving. What is the social aspect to it? I have to know where is one, what is the interaction of the social where life is happening, right? We understand there is a reason why we are doing a psychosocial assessment or evaluation because we know there is a social component to the child's behavior, but the interaction is only on the child as a child, right? Now let's look at the psychological aspect of it. Now the biggest problem I have with this section is the word mental capacity, and it also says mental capacity to be tried as an adult. How are we going to determine that? I mean, as a mental health professional, what is the way that you can even determine that? I'm still arguing on it. I mean, even after sitting here for this long in the CQRC, I still don't know what the report contains, right? So my question is to Ms. Cathy, what is it that you're going to do to answer the question of a child's mental capacity? And to recognize what is the GTV take from that report to answer this question of mental capacity? I mean, I'm sure there will be this argument about mental age, and that is another word that I do not appreciate. I mean, how do we even determine a child's mental age? I'm telling you right now, with the access to information, we have enough access to information that children have. Today, 12 to 14-year-olds are having conversations, which in our era we probably had in context. That is the kind of conversation that's happening. So you assess a child, the child will definitely have the mental capacity of an adult. But does the child have the executive function to decide this is what I should be doing right now? Or even, most children you ask them, do you know what the consequences of this actions? Yes, I do. Most children in ADHD you ask them, they have done something wrong, you ask them, do you know what will happen if you do this? Absolutely do. But what happened at that point? Answer that's it. That is the executive function, right? And that's the reason why we say that we function of accepting changes when speaking about our teacher. So my question is this: what do you give as a mental health professional? Would you take as a GGP member to answer that particular question? I'm still unclear on that. Thank you.
Congratulations.
I mean, I'm not questioning my questions very late, but when you look at the PA report, does that not sort of put the JJ one in a position where they automatically seek to see any incriminating sort of evidence in the report to see if this kid has the capacity to do this? So they automatically place the child in a position where it's already a trial before the trial has even begun. And my second question is that when these sort of laws are made, they are made in a reaction scenario, like the Delhi case and the Pune case, and the US news and Hyderabad case that did bring out very violent social storm. And these laws are meant to address scenarios like these. But as Swagata pointed out, these scenarios are only the ones that make the news. And a lot of these scenarios exist in the shadows, and these laws affect them as well. So, and then laws like these come out, the natural problem that arises while having these conferences, the lack of resources or the ability to handle these laws as they may be intended to, maybe the intention was to address the problems, is not being ascertained. So, what is the practical step, the middle path to walk between making laws for the betterment and having and making use of what we have to address these issues?
Thank you for the question, Cathy. I can speak from enhances what we practice here. In terms of the psychosocial part, as we consider any child, even with mental difficulties or a child in conflict with law, it is always a biopsychosocial phenomenon, especially with children. Children in conflict with law as an individual, as a personal listening, I see it as largely a societal problem. Yes, psychological individuals said. The society of what issues has led to that issues what I personally see the problem. In terms of NIMHANS, what performer we use is based on grassroots research. I think it started from Dr. Psychiatric. There was a team of research which was done on children and with consultation of many professionals. There is a performer where we have broken down mental capacity into cognitive abilities as per our understanding. Law doesn't tell anything about mental capacity, what is mental capacity. So mental capacity we've broken down to a developmental perspective. It is basically a developmental assessment. I wouldn't call it a mental capacity assessment. Developmentally, how is the child vulnerable? How is the child's trajectory has been? So I would just assess the cognitive abilities, the emotional abilities, the understanding of the circumstances of the child. As you said, the child might have well aware about all the circumstances. But longitudinally, how has been the child's thought patterns? How has been the child's mood? What was the child's exposure to? So we also address the mini kit. Mini kit is basically a diagnostic screening for all the psychiatric disorders. Does the child fall in line for universal disorder? Does the child have vulnerability of universal disorder? How has been the child's family like? So how has been the child's attachment patterns like? What was the child a school dropout? How has been the family supervision and monitoring? What were the kind of peers the child had? Was it peers elder than them who are not going to school, who are working? Was there a possibility for gang activities? There are questions understanding the life skills of the child. So basically, a holistic development assessment of what is this child's trajectory and what was the background of this child which led to the child to do. Again, it could be informative, but then what was the background of the child to put in this vulnerable situation? No matter the child has committed the offense or not committed, for the child to be brought in front of law, what has been the psychosocial factors into that? As per assessment, our role stands here. How are we interventions happen only when the child comes back to follow. Definitely, given our recommendations and suggestions, CCC the child will benefit from. How are we helping children turn out for follow-up? The percentage who has turned out for follow-up, I think certain cases are being going consistently well. The child has been able to, rehabilitate, go for vocational training centers, join that school, NIMHANS has been an option for few children. Parents have started to become more understanding, more monitoring. So, there are a lot of things as a system. So, I think the children and the families who came back over to see the